Jesus. People on Facebook see that first 60 seconds.
Good morning and welcome to AM News Network presents The Morning Report with Rachel Baird and Ed Peruta. We're here every Monday through Thursday from 7 to 7:30 a.m., or at least we try to be, Ed. We also do a show on Saturdays from 4 to 6, Summary Judgment, all from our American News Media Center studio here in Harwinton, Connecticut, where we transmit live. And our shows are now being replayed on Cablevision and Charter.
Right. Charter's going to have the morning report from 7 to 9 a.m. on Fridays. All 4 segments will repeat on Friday mornings, but the people that are watching have to realize that they're watching tape or recorded and whatever.
Ed, what is this sitting in the middle of us today?
This is your obsession. This is an obsession with Dunkin' Donuts trays.
I only wish I would have started doing it sooner because this room would be filled.
Yeah, this is about a month's worth.
Yeah, this is not even that much, but we're going to keep collecting them all because we're recycling.
So here's today's.
Yes, we're contributing to the clean environment of the earth.
Is this not ridiculous?
And then we're going to return them to Dunkin' Donuts all at one time and recycle.
And we'll videotape that.
Also, another thing I'd like to do on a daily basis, Ed, and I quickly drew this up. Day 14. Do you know what that means?
No.
We're going to count the days, not including weekends or holidays, since you have requested the legal opinion from the City of Hartford, which the Civilian Review Board relies upon to table civilian complaints against police officers if the civilian has filed a federal lawsuit.
Or filed a lawsuit.
A lawsuit. We want to see that legal opinion. It's the phantom legal opinion.
I've said this repeatedly.
You asked for it.
There is no downside to denying a Freedom of Information request in the state of Connecticut. The Freedom of Information Commission does not levy the civil penalties that are permitted by law against the agencies or employees who have denied access to records. There is no downside.
And it's day 14. Of course, you have 30 days to file a complaint if a government agency does not comply with the Freedom of Information Act, and that does count weekends and holidays. So maybe I should start counting this differently because I'm counting from September 21st. Let me explain how that works. So I should start counting differently.
You make the request, and you give them a full 30 days, and you let the time run out on that 30 days. And on the 31st day or the 131st day, you repeat the request. And then the 32nd day or the 132nd day, you file your complaint. They will sit there and say, well, he filed it and he filed the complaint the next day. No, I gave you 30 days. I gave you 130 days. You didn't comply. I asked for prompt access. So you had all of that time to prepare for this request. So that is my strategy, is to give the city more than enough time to promptly provide access to inspect the public record, and then to file and complain. And then the Freedom of Information Commission will take 6 to 9 months to schedule it for a hearing. And what the government agencies do is they use that delay to get beyond the news cycle so that it's no longer news. Example, what good is it going to be to find out that the legal opinion doesn't exist or that the legal opinion is flawed? It's already been tabled. Now, I intend to go to a meeting and ask them to take off the table my complaint and to investigate it.
But you know that I went down to City Hall in Hartford and looked for your complaint on the agendas from 2015 and 16 and didn't see it.
And it takes a motion to table.
Yeah, we need to go down there and check for 2014, but that means we have to go up to Corporation Counsel's office, which I have a feeling they're not going to be as forthcoming with the file as the town clerk was with the files that she had. I just have a feeling.
I'm not going to say what I'm thinking.
So yesterday, I opened up the Connecticut Law Tribune, which
Let's do something real quick before you do this. Okay. Cliff, can you go to computer number 2? We have a 45-second clip.
Oh boy, he's not in a good mood.
We have a
today.
45-second clip of an American News camera that went to East Hartford to the plane crash. And we're not going to comment on it. We just want you to know that American News was the first, I guess, news camera at the East Hartford plane crash yesterday. Obviously, it was blocked off, and you're going to see a lot of public safety activity, but American News, from what I understand, was the first camera on the scene. So if he could roll that for 45 seconds, here it goes.
The East Hartford Police Department and East Hartford Fire Departments received multiple 911 calls regarding
have to
a
try our new
twin-engine
thing.
aircraft that appeared to crash on Main Street here in East Hartford in the area of the 400 block of Main Street. Upon arrival, we did observe the crash scene. There was another vehicle nearby that does not appear to be directly involved in it, but two occupants of that vehicle were transported to the hospital. As for the aircraft itself, it appears to have taken off from Brainerd Airport, and circumstances afterwards are yet undetermined. There were 2 occupants of that aircraft, one of which was transported to the hospital. The second is unaccounted for at this time. The investigation is currently ongoing and active, and we will be updating everyone as soon as we get more information.
Okay.
That was excellent footage.
That's footage by American News camera Pedro Rivera of Hartford.
If our Facebook viewers were wondering why I got up, I was going to experiment with turning the tablet around so they could actually see the screen, what was going on, but there wasn't enough time to try it. It was only 45 seconds. So we'll continue to work on that.
Facebook does not have a feature where you can switch and bring a piece of tape in. It only does what you see.
So, yeah, we have to work on that. If anybody has any ideas, let us know.
The footage will be up on YouTube later today. So now, Kevin Kane.
Well, I'm trying to find the story here. Apparently, in the Connecticut Law Tribune, there was an editorial regarding the Brady issue
Brady v. Maryland. Exculpatory information
Here it is.
must be provided to the defense. And according to state law, regulation, case law, and whatever, when a police department realizes there's a serious issue with an officer involved, that is exculpatory. The police department is obligated to tell the prosecutor. The prosecutor is then obligated to tell the defense. Or in some cases, it could be multiple defenses that there is a problem with the officer, his credibility, his integrity, or whatever. That's exculpatory and must be disclosed. Is that a fair way of explaining Brady?
Yeah, of course.
Okay. We first ran into it in a case where on the eve of trial, a prosecutor wanted to talk to Rachel and informed her that the arresting officer, if called to the stand, may plead the Fifth Amendment to questions asked, and et cetera, et cetera. And that was the first we found out about it. And we claimed that was a Brady issue. Rachel, subsequent to that issue, wrote a letter to the Chief State's Attorney's Office inquiring about the Brady list, or Brady. I, in turn, called the Connecticut State Police and talked to an attorney in legal affairs named Janet Ainsworth and asked her, did you supply the information about Trooper Bergeron to the prosecutor when you had the issue? And her answer to me was, we don't supply the information unless somebody asks.
Yeah.
I got a problem with that.
Yeah, well, let's get to this. There was an editorial in the Connecticut Law Tribune, jail for misbehaving prosecutors is not the answer, but we must find one. And that was October 5th. And the way the editorial describes Brady is Brady v. Maryland and its progeny provide that prosecutors have an affirmative obligation to disclose information that is not only exculpatory, but also tends to undermine their own case by impeachment of their witnesses. And in many cases, their primary witnesses are police officers. So anything that would undermine the credibility of a police officer is exculpatory and should be disclosed to defense attorneys. Now, this article goes on to say that in Connecticut, a spotlight should be put on prosecutors and whether they in fact follow Brady. Now, I'm trying to find the article from yesterday that never got printed out, and I'm not sure I'm going to be able to find it. And you don't have your computer, so I'm going to try to find it.
Well, then I have to ask a question. Are prosecutors in Hartford telling all of the defense attorneys where Officer Sean Spell was involved in the case, in the arrest, in the investigation, the facts surrounding Sean Spell's recent June 2016 incident?
I mean, we weren't told, and we have a federal case against the man where there's an ongoing duty to supplement discovery, and we weren't told about it, and the discovery that we received still shows that he's working on the job. So I think that probably gives you a pretty good indication whether prosecutors are highlighting cases that Sean Spell was involved in and telling defense attorneys. But you know what? Most defense attorneys probably know about Sean Spell because it's been on the front page a couple times. It's all the other police officers that are involved in things that don't come to light and that the Hartford Police Department knows about and is supposed to tell the prosecutors. And as we know from a letter that I received from the state's attorney's office a couple of years ago, they have no procedure for that.
Well, I need to say something else. Now, it's my understanding that a Hartford police report written regarding the Flatbush Avenue incident was written by an Officer Barone.
Did I email you this Kevin Kane story? I mean, did they take it down off the Connecticut Law Tribune? I mean, why isn't it where it was yesterday? I can't find it, but go ahead.
The report on Flatbush Avenue is reported to me to have been written by Officer Barone, another defendant in our lawsuit. And I would think that in a case report regarding Flatbush Avenue, you would list the injuries to the individuals apprehended and how those injuries occurred, especially if it occurred from the sole or the heel of a police officer's boot. So that, you know, Officer Barone may be involved in this. Don't know. And won't know until State's Attorney Shepak makes his decision one way or the other. If he makes his decision that there will be no criminal charges, then I believe the file becomes public and we all get to look at it. If he brings charges, then at least we're going to hear in open court what happened if it goes to trial. Mm-hmm. But I would think that Mr. Spell would take a deal.
Okay. Well, we have to talk about something else because I simply can't find it.
Okay.
Go ahead. I mean, I'm going to keep looking for it, but I can't find it.
I believe that you may have emailed me a link to it because that you have to log in to get to it and you can't find it.
So tell us more about the video yesterday. I'm looking for it.
Well, what happened was I was up here in Harwinton. I got a phone call notifying me of a plane crash on Main Street in East Hartford. Plane was fully involved. One person was out. One person was still in the wreckage. And obviously I can't get to East Hartford that quick, so I made a phone call to what we have as the closest camera to the incident. I called Pedro Rivera. Pedro Rivera responded to the scene and captured what he captured. Now, obviously, if everybody has the same footage, they're not going to take ours when they've got theirs. But I will tell you, in looking at the internet, there are a lot of photographs taken by what appear to be cell phones of the actual crash scene, flames. So, in my opinion, there were probably 50 reporters of the civilian variety standing around videotaping a plane crash on Main Street in East Hartford. It's supposed to have occurred in the vicinity of Goodwin College, so I would imagine a lot of college kids took their cell phones out and started to record.
Okay, I found it. Letter to the editorial board, Kevin Kane, October 7th. And he's reacting to the editorial in the Connecticut Law Tribune saying we need to do something to enforce the rule, the law of the land, that prosecutors have to disclose exculpatory information, including information that would undermine the credibility of their witnesses, police officers.
Before you read Kevin Kane's letter, I have one comment. Everybody keep this in your mind. Chief State's Attorney Kevin Kane is oblivious. He knows nothing about the topic on which he writes regarding his own office. He knows nothing about a letter written by Attorney Baird and a response by his agency to Attorney Baird regarding Brady List.
Okay, let's get started, Ed. He says, just as hard cases make for bad law, bad facts make for bad editorials. So he's calling the Connecticut Law Tribune article editorial bad. Such is the case with the Connecticut Law Tribune's recent editorial, Jail for Misbehaving Prosecutors is not the answer, but we must find one. He says no basis in reality exists to support the editorial board's statement that Connecticut prosecutors routinely fail to comply with the mandate of Brady v. Maryland, or its shamefully misleading suggestion that Connecticut courts have been inundated with reports of misconduct of this nature. Any objective person who takes the time to study Connecticut's reported judicial decisions will reach the same conclusion. Is that the study he did of recent Connecticut judicial decisions? Do you know what percentage of cases wind up being the subject matter of judicial decisions? It's got to be less than 1%.
All right.
The majority of cases get plea bargained out because people are afraid to go to trial because of the expense and because they don't trust the judicial system. So to look at judicial decisions as your basis for any opinion about what's actually going on in the criminal justice system, his credibility is severely undermined already just with that one sentence. Go ahead.
Did he use the phrase of what you just read, failure to routinely comply?
Yes.
Are those his exact words?
No.
What were his exact words where it said failure to?
No basis in reality exists to support the editorial board's statement that Connecticut prosecutors routinely fail to comply with the mandate of Brady v. Maryland.
Routinely fail to comply.
That's what the Connecticut Law Tribune said, and he's saying that's not true, that they have no basis in reality because they should check judicial decisions. Like judicial decisions have anything to do with what happens on a day-to-day basis in a GA court.
This is the basis for my making the statement that Kevin Kane, the Chief State's Attorney for Connecticut, does not know what's going on in the GAs and the Superior Courts of Connecticut. He does not know.
He says Brady failures are extremely rare. Is that based on his review of judicial decisions? And virtually all of those are inadvertent lapses. I'll tell you why he says they're inadvertent lapses, and I'm going to get to that because I have a letter from his agency saying they have no policy or procedure for compliance with Brady, so you bet there's inadvertent lapses, but those lapses are on purpose because if you don't have a policy or procedure, of course there's going to be lapses. You have deliberately set up a system where there's lapses, where people are not held accountable. They're not the type of intentional act which the editorial shamefully implies are regular occurrences, deviously designed to cheat and hide evidence to win. And you know what? I'm not even sure, I don't know, devious. A lot of it is because, I don't know what a lot of it's because, but I know the fact that you don't have policy or procedure, then you are condoning these lapses that he's talking about.
I can read this fast. Rachel wrote a letter
No, but
on
it's
January
not good
20
when you read letters fast. Read it, but it's not
Rachel
good when you
wrote
read
a
it
letter
fast, 'cause
on
people don't get it.
January 27th, 2014 to Kevin T. Kane, Chief State's Attorney, Division of Criminal Justice.
Don't read
And I'm
fast.
just going to go...
Don't read fast.
I'm just going to go through the 8 things. If no answers are forthcoming, please consider the following questions as requests for responsive records.
I wrote a letter to Kevin Kane asking him for their policies and procedures with regard to complying with Brady v. Maryland. Under the Freedom of Information Act, I wrote him.
Now I'm going to read. 1. What policies and procedures does the Division of Criminal Justice follow to track documented issues impacting the credibility of sworn officers on whom criminal prosecutions rely for testimonial and or tangible evidence?
What date is that?
January 27th, 2014.
2.5 years ago.
2. When did the Division of Criminal Justice learn the date of, and it's Trooper Bergeron's suspension and resignation? 3. What steps has the Division of Criminal Justice taken to review all arraignment/probable cause affidavits submitted by Trooper Bergeron to the courts, used by the courts to find probable cause to incarcerate individuals pending trial, and placed in court clerks' files for public access? 4. What steps has the Division of Criminal Justice taken to review all pending cases based on investigations conducted by or assisted by Trooper Bergeron, incident reports sworn to by Bergeron, and statements taken by Bergeron? 5. What steps has the Division of Criminal Justice taken to review all cases ending with convictions based on investigations conducted by or assisted by Bergeron, incident reports sworn to by Bergeron, and statements taken by Bergeron? 6. Does the Division of Criminal Justice request and or maintain warrants submitted for the arrest of sworn officers, internal affairs investigation reports pertaining to the conduct of sworn officers, and or any other documentation pertaining to the conduct of officers on whom criminal prosecutions rely for testimonial and or tangible evidence?
And the reason that came up was the state police went to the prosecutor's office with evidence that the state trooper should be arrested. So the prosecutor cannot deny that he had information about this trooper impacting his credibility. Meanwhile, the same prosecutor's office was negotiating with me and leading up to trial, where they intended to use that same officer as a witness whom they had reports about doing wrongdoing, but because the prosecutor refused to sign the warrant, the police officer never got arrested.
Right. Right. 7. What records does the Division of Criminal Justice have pertaining to Bergeron's credibility and when they were received?
That's shady. Very shady.
8. What steps has the Division of Criminal Justice taken to review all affidavits in support of arrest and search warrants which relied on information provided by Bergeron? Now,
because we learned when we did a hearing with the Berlin Police Department here in Connecticut that the officer who wrote the arrest warrant and signed it knew nothing about it and just had collected information from other officers and put that information in the arrest warrant. So it's not enough to actually look for arrest warrants and police reports that an officer signed off on, you have to look at everything to know what information was gathered from that police officer, where another officer used that information to draft an arrest warrant. So the problem mushrooms really through the whole department.
Let me see if I can do this.
But let me say, the most important thing I asked for, what policies and procedures does the Division of Criminal Justice follow to track documented issues impacting the credibility of sworn officers on whom criminal prosecutions rely for testimony and or tangible evidence? That's Brady. And let's look at the response.
I'll read it.
No, that's not it. That's not it, Ed.
Oh,
I don't know where it is. Here's the response.
I'll read it. This is to Attorney Rachel Baird.
What date is it?
This is in February of 2014.
Right.
Dear Attorney Baird, I write to respond to your recent request for documents made pursuant to Connecticut Freedom of Information Act. As previously noted, for the purposes of FOI, the Division of Criminal Justice is a public agency in its administrative function only. The Division of Criminal Justice responds to your numbered request as follows.
Don't read fast.
Well, I got it written.
Yeah.
Okay. The division does not have any administrative policies or procedures responsive to this request, although the division is currently contemplating the establishment of such policy.
Mr. Kane does not mention that at all in his response to the Connecticut Law Tribune editorial board. He does not say, we don't have any way of knowing whether police officers or agencies are giving us information. We told Attorney Baird 2.5 years ago that we're thinking about working on it. And this is the status of our thinking about working on it right now.
Now, let me. I'm
thinking about working on complying with the United States Supreme Court case of Brady v. Maryland. I'm thinking about it.
Let me read number 2.
What if somebody who got arrested said, well, I'm thinking about following the law and, not robbing banks, but I'm just thinking about it. Number 2? Oh, well, the rest of my request that Ed read, these numbered requests pertain to the division's investigative and or prosecutorial function, and for the aforementioned reasons, the requests are denied. Maybe they should have referred me to those judicial decisions where apparently all the answers are found about things that prosecutors don't want you to know.
In other words,
why on earth would you rely on judicial decisions?
In other words,
it's insane.
You cannot question or ask to see documents and records pertaining to the prosecutorial function, even though there is more than ample evidence out there that they are not complying with the Supreme Court decision of Brady v. Maryland.
And I can think of one client in particular, and he knows who he is, who was just astounded, basically, when I told him that you can't request files from prosecutors. You can't. Nobody can look into what's going on there to know whether, we know there's no policy or procedure for gathering information about the credibility of police officers. It's like those monkeys you see no evil, hear no evil, speak no evil. Well, I guess you speak it, but you just close your eyes to everything, and then you act like everything's okay. And that's what Kevin Kane is doing, and his opinion incenses me, and I wish that I could write a counter opinion and have it put in the Connecticut Law Tribune, and I'm going to submit my documentation that was never mentioned by Mr. Kane in his response, and hopefully I'll have an opportunity to do that, because that incenses me.
I'm going to say this in closing. The reason the prosecutors take so long to make a decision is to let as many criminal cases go through the system as possible without having to make notice
But just
under Brady.
think about it. This prosecutor in New London County had information from the state police about another state police officer saying he was engaged in criminal activity, and that police officer, who the other police officer said was engaged in criminal activity, the prosecutor was relying on him as a witness and chose not to arrest him. Can you think of a bigger conflict of interest? Not only chose not to arrest him, but chose not to tell defense attorneys about it. And nobody cares.
I think we're done.
Done. See you tomorrow.